Hi, are you applying for a marriage-based green card? Beware of mistakes that could cost you everything. Today, I want to talk about some of the biggest mistakes that couples make that lead them to denials, how they can avoid them, and what you need to know. Okay? So, the first mistake that I want to talk about is failing to prove a bona fide marriage. Okay? So, it's one of the most common reasons why denials happen in marriage-based green cards. Immigration officers, they look for strong evidence that your marriage is genuine and that you're not just applying just to get a green card. So, what are some examples of weak evidence that could raise red flags in your case? Number one, only submitting a marriage certificate, right? Yes, you need to submit proof that you're legally married, but you also want to submit other evidence that shows that this marriage is ongoing and true. Not submitting shared financial documents like bank accounts, lease agreements, bills that you share together. Regarding bank accounts, though, I want to emphasize that it is not enough to just submit a bank account that has both your names on it. USCIS wants to see that this bank account is an operating account where you guys are using to live your daily lives. So, a bank account that just has a little bit of cash in it and it's not active is going to be a red flag. And also, I like to include photos of the couple together, not just photos on the wedding day. So photos that do not show that you've been together over a period of time can also be a reason that they raise a red flag in your case. Okay, so how do you avoid these mistakes? You want to submit joint documents like your lease agreement, your mortgage, utility bills, insurance, taxes, and also you want to submit an active bank account that you're actually using, an operating account. Also, you want to provide varied photos together, like I said, family pictures, family gatherings, holidays, pictures of you on vacation, showing that you're living your daily lives. You can also get affidavits from friends and family who can confirm your relationship and that it is a true and bona fide relationship. Another mistake that we see is rushing the process and submitting incomplete forms. So, filing too quickly without double checking everything can get your application rejected before it even gets reviewed. And this can also lead to an extended wait time. So, you have to consider that even small mistakes like missing a signature or providing incorrect information can lead to delays and even an outright denial in your case. So, what are some of the common mistakes that we see? People forget to sign the forms, leaving required areas or fields blank, including incorrect dates, especially when it comes to the marriage date or dates to your prior addresses, right? How do you avoid this? So, number one, you want to carefully review all forms before you submit it. USCIS has a checklist on their website. You can use the checklist as a guide as to what you need to include. And if you're really unsure about how to fill out the form, consider speaking with an immigration attorney. That will save you a lot of headache in the long run. Another common mistake is that couples attend the interview unprepared, right? The green card interview is a big deal. So if you and your spouse aren't prepared, you can end up giving inconsistent answers. You can end up sounding like you are not in a real marriage. And this can make the officers very suspicious of your relationship and lead to a denial. So, some of the common mistakes that we see when it comes to interviews is that couples end up giving different answers about how they met, not remembering important details about each other, and also appearing nervous or hesitant when answering questions. So, how do you want to avoid this, right? You want to practice interview questions together. How did you meet? What's your spouse's favorite food? Who does the cooking? You want to be honest. You don't want to memorize fake stories about each other, right? But you want to prepare for potential questions that might come up. Okay. I have a free ebook on my website where I actually give you sample questions that could come up during a marriage based interview. You can feel free to reach out to me directly or go to my website, just download the book. But preparing with each other, going over your application before the interview is going to help you feel more confident, right, in answering the questions. And also, you want to bring up to date documents that will show that your marriage is bona fide and ongoing. So, more evidence that you didn't submit prior the first time will also be helpful. So, anything new showing that you guys are continuing to build a life together, maybe you bought a house, maybe you had a child, you can bring evidence of this at the interview because it will also show that you have a continued bona fide marriage. Another common mistake is not disclosing past immigration or criminal history. Failing to disclose past immigration, prior marriages, or criminal history can lead to some serious trouble. USCIS does a background check, so they will find out. So it's very important that you are upfront with this information at the onset, okay? Some red flags that could trigger denial in this case is having a past visa overstay or illegal entry, prior arrest or convictions, even minor ones, and previous immigration applications with different information. So if you filled out information for an immigration petition in the past, you want to make sure that your information you're providing this time is consistent because they have the record already, right? So you don't want to lie. You don't want to misrepresent information. So how do you avoid this? Be honest on your application. Don't lie. Just put the real information, okay? If you have past issues, consult with an immigration attorney for guidance. If you have a prior immigration violations or prior criminal history, do not do this on your own. Work with an attorney. Your attorney will help you and guide you on the best way to move forward in your case. And if needed, file for a waiver before applying. There's a lot of times that people don't realize that even if you have a past immigration history that's not so good or past violations or criminal history, a waiver might be available for you and help you in your case and help you ultimately get an approval or get a green card. So you want to consider talking to an attorney before doing this. Another mistake that I see is people trying to use fraudulent or misleading information. Some people think that they can, quote, fix their case by providing information that's false, but let's be clear. This is one of the ways that you can make your situation even worse. It's one of the worst things that you can do. So some examples of fraudulent behavior is having a fake marriage, right? So applying for a green card based on a sham marriage, submitting doctored documents, and lying on your immigration forms. So you want to avoid this. Only provide true and accurate information. If you made past mistakes, again, consult an attorney to consider applying for a waiver. Maybe you don't even qualify for immigration benefits right now, right? Talk to an attorney. Talk to your attorney about situations that's happened in your past. There might be an immigration benefit that you do qualify for, and maybe there isn't one right now, but you don't want to put yourself in a situation where you're creating submitting false information in order to get a green card, because you're just going to get yourself in bigger trouble in the long run. So if your case has complications, like I mentioned earlier, past immigration issues, criminal history, missing documents, don't try to do this on your own. A good immigration attorney can help you navigate through the process and avoid costly mistakes. So if you are concerned about maybe something that happened in your past, talk to an attorney, schedule a consultation. We do consultations here in our office. We represent clients in all 50 states. We can help you with your case, or at least give you some legal options as to how to move forward with your case, okay? So I want to answer some frequently asked questions regarding this topic that I get a lot. So the first question is, what if we don't have a joint bank account or shared bills? Will our green card be denied? So not necessarily, but if you don't have a joint bank account, I'll be honest with you, it might raise a red flag. USCIS expects couples to share financial responsibility. So if you don't have joint accounts, you want to provide alternative evidence of your relationship, right? So I talked about some other options before. Showing that you've been together over time, affidavits from friends, travel records, text messages, emails, showing your communication regularly, right? If possible, you want to consider at least opening up a joint account and getting your both names on it and using the account, right? Making it active. Some couples might not have a joint bank account in the beginning because maybe the marriage is really new, but maybe you guys are on each other's life insurance, or you have maybe you wouldn't have filed taxes, but maybe you did file taxes together, right? Or maybe your spouse has added you to their work insurance, right? You have auto insurance together, right? There are different ways to show commingling of your finances. The USCIS definitely wants to see that couples are invested with each other financially. So not having a joint bank account can be a red flag, I'll be honest. But if you don't, it's not the end of the world. You just have to show strong evidence and other areas and maybe explain why you don't have one at this moment. And then bring one to the interview if you're called for an interview. Or when you open up a bank account, you can also submit additional evidence. So it's not the end of the world, but it's something that you do want to consider. So my spouse and I live apart due to work or school. Will this cause a problem? So yes, it can. USCIS, they expect married couples to live together, but there may be some legitimate reasons for why a couple will be living apart. And if this applies to you, you want to provide proof of that, proof of why you guys are currently not living together. You can also show proof of ongoing communication, right? So you don't live together, but you communicate, you talk all the time. Text messages, your call log, video chats. You can show travel records or flight tickets showing that you visit each other. So sometimes one couple might be in school while another couple works or their job requires them to work in another state at long periods of times. And that happens, right? If that's the case, just provide evidence of that, right? You can write a letter, and include this in your application explaining your situation. You can provide copies of a job offer letter. Maybe you got a job in another state and you have to work there in the meantime, or you're like I said earlier, you're in school, you can show proof of your enrollment. It is important to be able to explain that to USCIS why you're not living apart. Just living apart with no backstory, with no explanation, is going to raise a red flag and is going to lead to a denial ultimately. So what if I made a mistake on my application? Can I fix it? Yes, you can, but how you fix it may depend on when you catch the mistake. So before submitting it, again, double check your application, make sure everything's correct before you mail it out. After you submit it, but before the interview, you can bring the corrected information to the interview and explain the mistake to the officer. So you can make corrections at the interview. Sometimes if there is some information that USCIS is not clear about in your application, or maybe you didn't submit evidence that they need in order to make a decision, they might issue you an RFE, a request for evidence, and request that information to be sent to them. But if you do catch a mistake, yes, you can make a change. If it's after the interview, right, and it's a serious mistake, I would recommend contacting an immigration attorney immediately, okay, so that you can see if there's any way to fix it prior to the decision being sent out to you. How long does the marriage green card process take? So processing times vary based on the location of USCIS offices and the workload, right, that they have at that time. So on average, with a spouse visa, who's married to a U.S. citizen, it can be anywhere from 12 to 18 months. I've seen shorter, I've seen longer. If your spouse is a green card holder, it could be 18 to 36 months. Again, it could be longer, it could be shorter. Consular processing, which is when you're applying outside the country, can take anywhere from 18 to 24 months. What you want to do is you want to check USCIS processing timelines for your specific case type. You can do this online and you'll be able to see what the processing time is for your type of case at the moment that you're checking on their website. Do we need to have a big wedding to prove our marriage is real? No. Big weddings is not enough to show that a marriage is real, I'll tell you that. But if you had a small wedding or you eloped, especially with the eloping, right? Let's say you were not in a relationship for a very long time, then just to be safe, you might want to provide extra evidence showing that the marriage is legitimate. I talked about a bunch of different types of evidence you could submit. Again, you want to show photos of different occasions together. You can provide a receipt of the ring, if your spouse purchased it for you. Maybe you had a wedding dinner, honeymoon. And you can ask friends or family who know about your marriage, and they can actually attest to the legitimacy to write you an affidavit. But ultimately, no, you don't need a big wedding. A lot of times people don't even have a wedding. They just go to the courthouse and they get married, and their marriage is real. They just didn't want a wedding. It's fine, so you don't need a wedding, okay? What if my spouse is undocumented or has overstayed their visa? So if your spouse entered the U.S. legally but overstayed, and you're a citizen, then they may be eligible to adjust their status without leaving the country, right? USCIS will forgive their overstay because you're a citizen, and they'll be able to apply for the green card here without leaving the country. However, if they entered illegally, then they would need to apply for a waiver And waivers are very complicated, they're very complex. So you want to not do this on your own. You want to work with an attorney, but they would have to apply ultimately for a waiver of their unlawful presence and also their illegal entry. And then ultimately they'll be able to, if approved, go back home to their home country and enter through consular processing, which is a different process from adjustment of status. So undocumented, but within legal entry into the country, yes, you'll be able to get a green card and do what we call a one-step concurrent filing, meaning you apply for the marriage petition with the adjustment of status at the same time. But that's only if you had a legal entry and the petitioner is a U.S. citizen. So what happens if I get divorced before I get my green card? This is a really good question. So if you're still in the process, and your application is likely to get denied unless you can qualify for some sort of exception, such as proving that the marriage was real but ended due to abuse. And I do this all the time in my firm. There, it's called a vow of self-petition, and those are for those individuals who were married but they were abuse victims, right? And they're able to prove that they were abused or they suffered some sort of extreme cruelty in the marriage. So that's an exception, right? So even if divorced, those individuals can still apply for a green card. If there was an abuse and the marriage ended while the application was being reviewed and processed and you didn't get a response yet, unfortunately it's going to be denied because you're no longer in a bona fide marriage, right? So ultimately the marriage is what's needed to get the green card. If you already received a conditional green card, so that's the 2-year green card that you get, you'll need to file Form I-751 and request a waiver of the joint filing. And then you also have to submit evidence that the divorce happened and the marriage is ended in order for you to avoid doing the joint filing, which is required for couples and required for individuals who received a conditional green card. Okay, so there are options for you. So what happens if we get different answers in the interview, or if you're asked questions and you're giving different answers? So if your answers don't match, it could raise suspicions about whether your marriage is real, and officers might decide to separate you for a Stokes interview, which is when they suspect that there's marriage fraud. So you want to be careful because in this interview, they're going to ask very detailed questions, personal questions separately, and they're going to compare your answers, right? They want to know whether or not you guys are in a legitimate marriage. So to avoid this, you want to practice common questions together. How did you meet? What side of the bed does your spouse sleep on, right? Who goes to work first? It could be so many different questions that they could ask you. Be comfortable and feel comfortable answering these types of questions. Now, if you don't know the answer, you don't know. You don't want to make something up. You want to be honest with the officers. So it's okay to say that you forgot or you don't remember. Don't try and guess and don't try to create facts either. You just want to be as honest as possible. But if you do give inconsistent answers and you are not able to answer some simple questions that couples who are in real marriages would be able to answer, it's going to raise a red flag. They're probably going to separate you. And ultimately, they could decide to do further investigation, like a house visit, or just deny your application outright. So can I work while waiting for my green card? It depends. If you apply for adjustment of status, which is the Form I-485, you can also apply for a work permit, which is the Form I-765. It usually takes about 3 to 6 months to be approved. It could be a little longer, but on average about 3 to 6 months. And once approved, you'll be able to work legally while you're waiting for your green card to be adjudicated. So if you're applying for adjustment of status and it's pending, you can apply. You can get a work permit. So those are for the folks who are able to adjust their status. Many times it's an individual who has a U.S. citizen spouse who's filing for them. But yes, ultimately, once you apply for the EAD, Employment Authorization Document, which is the work permit, you'll be able to work while you're waiting for your green card application to be approved. If you have any questions about the marriage green card process, you want me to answer your questions here on my channel, then drop them in the comments, or you can send me a message. But I'm happy to answer these questions. These are really common questions that we get a lot. People are constantly wondering, what their options are when it comes to the marriage-based green card. People are concerned about how to go about the process. If you are one of those individuals and you need one-on-one help with your case, you can reach out to me. I represent clients in all 50 states. I'd love to help you. I'd love to work with you. And again, thank you for watching this video. If you watch it to the end, thank you. You are a trooper. If you know anybody that's interested in this information, please share. And also, if you enjoyed the content that I provided today, like it, subscribe to the channel so you can stay up to date anytime I post a video about immigration. And thank you for joining me. And I'll see you in the next one. Take care. Bye.